next one comes at 1:12. This is, counsel, if you want to come up here, this is pretty soft to hear, but I was able to hear it here. Okay, did you hear that? Did you hear that? Yes.
Okay, so for the record, those statements come at approximately 7:30 to 7:50. The next set of statements come approximately 23 minutes and 50 seconds. And the statement in the patrol car comes around 1 hour, 12 minutes, and 37 seconds. Is there anything further, Mr. Davidson, that you want to place on the record than what is contained in your memorandum?
Very briefly, Your Honor.
Okay.
Your Honor, I pulled out 3 segments of the footage from Officer Park's body cam and from his dash cam, and it mirrors exactly what Your Honor pulled out. So I think the court and the defense are looking at the same things. It's very clear in that first segment, Stephen makes statements to the effect, or asking questions to the effect, why did they hit me? Why did they hurt me? Why did they punch me? Why did they chase me? In the second clip, he could be heard saying what I believe is, why were they trying to kill me? In the third clip, he says, I thought I was going to die. There's also a statement in the second clip, why did you make me do that? These are all statements that were made at the scene by the court, by the parking lot at Mountain View before Mr. Jones was transported to the police station. No dispute about that. And this is what Mr. Barker said as he stood in front of the jury 2 days ago. He's admitting right there that he did something wrong. He's not discussing that he was justified. He's not saying that what he did was correct or right. The defendant realized in that moment that he was arrested for a reason, that what he did was wrong. Now, it wasn't until later, of course, when he had an audience with the police in a police station on the record that he started talking about, well, these people were trying to kill me. Right. But in that moment, in introspection, he knew that what he had done was wrong. Even the defendant doesn't believe he was justified. There's simply no way to listen to that and read this and come to a conclusion other than the fact that the prosecutor was being mendacious when he stood before the jury and made these comments and left them with the impression, intentionally, that Stephen did not articulate anything regarding the justification for his actions, his concern for himself, his concern for his friends, his belief he was acting in self-defense, until much later on when he was at the police station, after he had a chance to think about it and reflect, and in the words of the prosecutor, think about the kind of trouble he was in. What's particularly concerning about this, Judge, is that this was not some offhand remark the prosecutor made when he wasn't thinking. This was something, according to his statements yesterday and the day before, that he apparently had thought through and worked through with co-counsel. And after taking an opportunity to look at it, apparently thought that that was an appropriate thing to say to the jury. I don't know how one can credibly make that argument. I think the only question here is, what is the remedy? If we're not going to grant a mistrial, I think that the procedure that was followed in the Ninth Circuit case Robinson that I provided before is the appropriate remedy. In fact, I think the facts in Robinson parallel what happened here quite closely. And what I would suggest, Your Honor, is that we allow the jury to hear this. I would also suggest, Your Honor, because Mr. Chase Jones's statements at the scene were also something that the prosecution affirmatively fought to keep out, and that Mr. Stephen Jones, told Chase Jones, these guys beat me up, it was in self-defense, and directed Chase Jones's attention to Nick Plecky, expressing the defendant's concern that Mr. Plecky was going to try to take Stephen's gun. I think that comes in too, because the statement Stephen made to Mr. Jones, the statement that Stephen made in the back of Officer Park's patrol car simply can't be reconciled with this misstatement that the prosecution foisted on the jury. And I think if we're to remedy this and give the jury a fair, full, and accurate picture of what Stephen said and when he said it, they need to be told what Chase Jones heard, and they need to hear these 3 clips. Thank you.
Thank you. Mr. Barker.
I'll argue the motion, Judge, because
Okay.
I was the attorney that argued the motion to keep out the self-serving hearsay. Judge, I think we need to start with self-serving hearsay. It's not just self-serving statements, but self-serving hearsay. The statements were inherently inadmissible. We just had to bring that issue up with the court prior to trial so that we didn't have to deal with it during trial. They're hearsay, inherently inadmissible, and the court made that rule. I also want to just point out before I begin, Judge, that this trial is a pursuit of justice, a pursuit of truth and justice. And the trial the evidence has gone to the jury for their deliberation at this point in time. And we're not just talking about justice for the defense, but we're also talking about justice for the victims. I think we need to keep that in mind, because the action that's already been taken at this stage may have already had an impact on our ability to find a just result. The concern of the state is that the jury began to deliberate on the case. It was given to them. They deliberated late in the day on Tuesday. They deliberated early in the day yesterday. It's not clear what the jury was told. It's not clear to the state anyways what the jury was told before they were sent home yesterday. I'm not sure what the bailiff said to the jury. You know, we work so hard over the course of a trial to make sure that we limit what they get, what they see, what they hear, to only the appropriate things that they should be considering. I think it's hard to argue that them being sent home yesterday is going to impact their deliberations. I think that the court indicated yesterday, without the issue really having been fleshed out, that there may have been some wrongdoing on the part of the prosecutor. Now, we expect jurors to follow the admonition and not pay attention to the media, but the media has run with that. And since the issues weren't even fleshed out, it's probably, at least gives an inaccurate representation of what took place yesterday.
Are you indicating that you think that the jurors disregarded my instruction not to view or read any media articles?
It's just a further argument of the possibility that the action that was taken yesterday, may have already tipped the scale in favor of the defense.
Well, let me tell you, the bailiff didn't say anything. I went back and addressed the jurors, and I simply said, an issue has arisen that the attorneys and I want to address, and I'm directing you not to further deliberate, but to come back tomorrow at 9 a.m. and begin your deliberations.
All right, well.
The response was from the jury foreperson was, does this mean you're not going to buy us lunch today?
Well, I very much appreciate that, Judge. I'm glad to hear that interaction took place. I'll start by indicating, Judge, the appropriate way to deal with the situation that we currently find ourselves in, and that is to allow the jury to deliberate on what they have and to come to a verdict without further influence. And here's why. There was, in fact, no wrongful argument. Okay? There was no inaccurate argument. I think we need to talk about first what counsel actually argued in their motion for a mistrial after the trial. And that was that the statements that were excluded by the court, okay, that somehow Mr. Barker's argument wasn't consistent with the statements that were excluded by the court. I'd like to point out that there's at least 2 or 3 statements that have been raised this morning or raised by counsel in his brief that were never a subject of discussion of the motion to exclude the self-serving hearsay. Counsel never previously raised what is obviously a virtually inaudible statement on the part of the defendant, which literally I heard for the first time today. Nobody argued it, and the court never considered it before yesterday. That statement, I thought I was going to die, was never considered. The court didn't hear it when it reviewed the...
No, I did. And in fact, I did make that decision that statement, I thought I was going to die, was in fact self-serving hearsay statement.
Wow. And
that was precluded.
Yesterday, Judge, well, first of all, I don't remember any discussion of that. Counsel never put it in a brief. And yesterday, no aspersion to Steve, but yesterday we tried to get the record of the court's rulings and couldn't find any specific indication of that statement. What I remember the court ruling was the why statements. Why did they chase me? Why did they hit me? Why were they trying to hurt me? Okay? We start from the presumption that and from the knowledge that those are in fact self-serving statements. It's my argument, and I haven't seen the record indicating otherwise. And this will go to a further argument of the appropriate way to handle this situation. But it's my recollection, and I haven't seen a record otherwise that indicates that statement, any die or kill statement, was uttered prior to the defendant being at the station. All right? And so the truth is that there wasn't any wrongful argument. There wasn't an inaccurate argument based on what the parties knew. So if you look at specifically what Mr. Barker argued during his close, it's factually accurate. It's true. So I would argue that the defense is arguing a false narrative here, Judge. The court stated on the record yesterday that the court didn't remember the specific statements that were excluded. Defense counsel didn't argue the specific statements that were excluded. Defense counsel didn't argue yesterday or 2 days ago a die or kill statement. So we have to look at Mr. Barker's argument to determine specifically what it was that he was talking about. His argument was very narrow. His statements, he was talking about the statements that were made by those individuals in the specific circumstances those individuals were in. So it was the Nick Acevedo statement. I don't know. Why did you do that? I don't know. That was the defendant's response. Nick Pletke, the statements that were made to him. or that he overheard something to the effect of the defendant not knowing why he did it. Both of those statements, Judge, if you consider in the context of time, came in between the two clusters of shots. That's the time frame that Mr. Barker was specifically referring to. When we're talking about the Labarro statement, that's in the cruiser after he had been taken into custody. And in that statement, he was asked, hey, was there anybody else? And he says, nobody else did anything wrong but me. The point of the argument was when direct inquiry was given to him, he didn't say self-defense. He said, I don't know why I did it. Nobody did anything wrong but me. And then Mr. Barker made the argument that no statements about kill were made until he was at the police station, which, you know, upon later specific review, and again, never having been previously argued by the defense, you can strain to hear something different. But we're only talking about misconduct if there's a good argument that it was actually known, and there isn't a good argument about that. And we'll get to how we know that in a minute. So what Mr. Barker said is actually true, but I guess, you know, reviewing much more closely, you could suggest otherwise. But
was this the state's CD?
Yes, Judge. But the argument that defense counsel made was that that counsel fought to keep statements out and then argued contrary to those. And what I'm saying to the court is that we weren't aware of those statements. We never argued to keep those specific statements out. Defense counsel never argued to get those specific statements in.
You didn't review that every single word that Mr. Jones made when you had that DVD?
We had the DVD, Judge. We didn't have a transcript of the DVD, which I'm sure counsel will agree with. And I had to kneel down like this, close to the speaker to even hear what the court's talking about here. So my point is that...
But you heard it.
Well, that's true, but the misconduct, Judge, the argument about misconduct is that he knowingly did something wrong. The counsel's not arguing that there was an error. Counsel is arguing that there was a knowing misrepresentation. And what I'm arguing is that this morning I heard that statement for the first time. I re-listened to these on my computer yesterday and did not hear those statements. Okay? They're very, very difficult to hear. So what I'm saying is that there's no knowing misconduct. Okay? It's an error, at best. And like I said, well, we'll get to it in a minute, but
let me see if I can short circuit this, because I want to make sure that we get to the end of this. I've read the briefs, and counsel just, I mean, I don't mean this derogatorily, but I know that counsel want to put their arguments on the record. The record is the arguments that you've already made in your briefs. Okay? And so what I'm asking for is anything other than what you've put in your briefs.
yes, and I'll offer it, Judge, but in part there's an issue because defense counsel raised what I would argue is new things in his brief, so, which I just got at 8 o'clock this morning.
The same as I did.
Right. So, if I may, Judge, I'd just like to flesh out the whole argument here. I'd like to refer to the Chase Jones statement at this point in time.
Okay.
So, we've already had the discussion about the Chase Jones statement. The state raised that statement. Defense counsel argued that statement. Defense counsel's arguing that the defendant said he was acting in self-defense to Chase Jones. The state argued, we already had this discussion, the court already correctly ruled, that we don't know what the defendant said to Chase Jones. Chase Jones told the police that there was stuff that the defendant may have said within that same statement, Chase Jones said that he didn't know what the defendant said. The statement was precluded not just because it was self-serving hearsay, but the state would argue it was precluded because it's not actually a statement, we don't know what was said. I'll refer to the court's own words on the subject from that hearing. This is the court, quote, I mean, I don't see that Mr. Jones's statements Mr. Jones's statements show any indicia of reliability because that's Chase Jones, by the way, because he doesn't even know what Mr. Jones said. And so those statements were precluded because they were filtered through another person who then admitted he didn't really know.
Okay, you need to, I understand you want to get on that, but for the purpose of the record, I've already stated what the record is that I'm considering it. And it has nothing to do with Mr. Jones's statements to Mr. Chase Jones.
Well,
I already placed on the record what statements I'm considering.
Okay.
Okay?
Well, I think it's necessary to bring it up because that's the only arguably self-defense oriented statement that was made during this period of time. These other statements are statements of maybe corroborative of facts that might subsequently support a claim of self-defense, but he didn't say they were self-defense. I was acting in self-defense. He said, why did they chase me? And I would suggest to the court that you'd need a heck of a lot more than somebody chasing you in order to be justified in self-defense. If I may, Judge, now I just need to catch up with my argument. I would argue that the defense memorandum and even the recordings we listened to this morning were not something that was being considered by Mr. Barker when he made his arguments. And again, I think it's important that the defense never argued them before. The case that the defense is citing to support its remedy in this matter is where the prosecutor argued facts that were not only not in evidence, but were factually inaccurate. That's actually, and that the prosecutor would have known that they were factually inaccurate. That's a different circumstance than what we find here.
Okay, let me see if I can short circuit that. I read the briefs. I don't find that Mr. Barker intentionally committed misconduct. All right? So I'm not going to grant a motion for mistrial based on prosecutorial misconduct. I think it was, again, I continue to say that I think it was an inadvertent statement. I think it was one that he discussed with you about should he make that statement. I think that's a consideration of am I going to go up against, am I going to walk up to the line? The problem with that is that, unfortunately it's this guy in the black robe that gets to ultimately determine where that line is. And I think that line was crossed. But I don't think it was intentional. I don't think it was rises to the level of intentional prosecutorial misconduct. I think it was an inadvertent miscalculation. Okay. So I'm not going to grant the mistrial on prosecutorial misconduct.
All right, Judge. I'll skip on to my next point then.
Okay.
And the next point is that this is an untimely way to deal with this situation. It's not the correct way to deal with the situation because any action that's taken at this point in time will push the jury potentially in the wrong direction by highlighting evidence that look, the argument snuck by the defense. Okay? Either that or they elected not to object to it at the time. A timely objection would have been the way to deal with this if they were really concerned about this situation. And I think it goes to also, when you talk about speech in the context of things and how they come across, okay, I think the court would agree that when you read things in a cold record, it comes across a little bit differently than it does in the moment when the argument is actually being made. And what we need to refer to is the impact that the argument had itself on the jurors. And I would argue that the impact is negligible or none because of the fact, and exemplified by the fact, that the defense didn't object at the time. They either didn't recognize it, weren't concerned about it, or strategically opted not to object to it. But if the argument were impactful, if they thought it were important, they would have objected to it at the time, and they didn't. So there is an expectation that objections come timely so that the appropriate remedy can be engaged in. If the court had found at that point in time that there was something that needed to be remedied, a corrective instruction could have been given, and that would have been, if necessary, and the state's not conceding it would have been, but if necessary, that would have been a seamless way of addressing the issue. At this point in time, to address it now would put undue weight onto the evidence that the court is proposing to give to the jury right now.
So let me ask, does a search for truth and justice end when the jury leaves my courtroom?
No, Judge, but a trial is not a perfect thing. A trial is a
Amen to
pursuit
that.
of perfection, right? And so decisions are made, decisions of whether to object or not object are made when the opportunity comes, when the opportunity comes up. And there's an expectation, the contemporaneous objection rule. There's an expectation that an objection should be made when there is grounds for it so that you can properly address it. And you know, when the jury gets the case, and to bring attention back or to offer new evidence is to place undue weight on that evidence. It's the reason for the contemporaneous objection rule. The appropriate way to deal with the situation is to wait until the jury finds a verdict, if they find a verdict, and then to deal with it as part of a new trial when all the parties have an opportunity to really think about this stuff, to actually have the record to refer to actually know what was ordered by the court at the March 23rd hearing, so that we can try to address the matter in the most appropriate way. I would argue, Judge, that the defense didn't recognize any problem with Mr. Barker's argument as it was given. It came at the beginning of the state's first close. The defense had ample opportunity to address it in a variety of different fashions. They could have objected at the time. They didn't. They could have addressed it in their close. They didn't. They could have asked for a curative instruction. They didn't. And what I suggest to you is that what those things give rise to is that there wasn't a noticeable impact of the argument at the time. So what we'd be doing if we did something different with the jury at this point in time is taking something that wasn't noticeable and making it much more weighty than it should be. We're not really, I agree with the court, we're not really talking about a motion for a mistrial here because obviously there's no misconduct that rises anywhere to the level that's required by the case law for prosecutorial misconduct or a mistrial in any fashion. The argument that we're talking about right now is properly the subject of a motion for a new trial under 24.1. So, and again, just some case law on that subject to the contemporaneous objection, Judge Estate v. Harris, to allow the defendant to permit an error to go unrectified and then, as here, claim the right to a mistrial or a new trial if he is convicted violates the contemporaneous objection rule. The time for what the court is currently considering has already passed. The jury's already begun their deliberations. They've already gotten the case. Now it's time to let the jury do their job and come to a verdict. Any other approach, Judge, I would argue, potentially creates a miscarriage of justice in the sense that now it's taking those scales that the court has worked so hard to keep even. It's taking those scales and just tipping them a little bit in the defendant's favor. And it's unfairly done. The defense could have addressed these matters, elected not to, in a timely fashion. And so the conclusion of my argument, Judge, is that obviously we're not talking about a mistrial. I would argue that the jury should be allowed to deliberate and come to a verdict, and then we can determine whether or not this issue had any impact. 24.1 is the correct approach. The state would argue that since the case is already gone and 24.1 directly addresses this particular argument, that the rule is that there isn't an appropriate way to deal with this at this time. We have to wait until the verdict comes. There obviously was no prosecutorial misconduct, and that Mr. Barker's argument was a fair and accurate argument at the time. If I may, Judge, I just want to ask Mr. Barker if there's any argument that he thinks that I've missed.
All right.
Judge, the only thing that Mr. Barker points out is that Randall, which I think is the case that the defense offered, is not controlling on this issue. We offered the court the controlling case law and rules that apply. Thank you.
All right, Mr. Davidson?
Thank you. Just a couple things in response to Mr. Shea's comments. I'm confident if the court inquires with its staff, it'll be able to take judicial notice that just yesterday, the prosecution was provided the court's minute entry from April 13, 2017. On page 10 of that minute entry, excuse me. On page 2 of that minute entry, second paragraph from the bottom, the court advises it previously ruled the state can correct the court if the court is wrong and it was made on the record. There are 3 why statements that the defendant made in the car, and then a statement to the effect, quote, I thought I was going to die. This is the minute entry that the state got yesterday. So I think that we should maybe view the assertion that they were completely unaware of what was on their own disclosure until 9 o'clock this morning with a jaundiced eye. I also think that it's important to note that Mr. Jones' statement that he thought he was going to die is not the only statement he made, which completely flies in the face of Mr. Barker's suggestion to the jury that Stephen didn't articulate anything related to self-defense until he was at the police department. I think the notion or the suggestion to this court that Mr. Barker's statement was very narrow and intended to suggest to the jury simply that Mr. Jones didn't use the word kill other than times after he was at the police station, I'm strained to find a reason even to respond to that, Judge, and I think it's self-evident why that just simply isn't a credible argument. I think that we also need to be mindful of the fact that this isn't a question of whether or not the court erred or didn't err when these statements were excluded. Our objection had nothing to do with Your Honor's decision to exclude these statements. We made a record on that. That's fine. Whether they were excluded properly or improperly, the fact of the matter is those statements were made. And when the state stands in front of the jury and makes a representation to them that is going to clearly leave them with the impression that statements Mr. Jones did make weren't made, that's not acting in the interest of pursuing justice. I'm sorry. That's acting in the interest of pursuing a conviction. And we should expect more from the prosecution in this case. The state relies on Harris to make the argument that the defense did not timely object. And in their next breath, they make the argument that we've raised this issue too early and it's premature and we should wait and see what the jury does before we could do this. Well, putting aside the internal inconsistency with the positions they're taking, we should also take a look at the case they're relying on, which, according to Mr. Shea, is more applicable than the Randall case that I cited. Harris didn't deal with prosecutorial misconduct or even innocent misstatements of fact or law to the jury in closing argument. Harris was a case about a jury selection process, something that happened at the very beginning of a trial when there was a late objection as to a motion to strike a juror.
It was a Batson challenge, wasn't it?
Yes, it was a Batson challenge. It's apples and oranges. I don't think, and I would challenge the state to find a case that more closely parallels what's happened here. Because in Randall, we not only dealt with a prosecutor that made a demonstrably false statement to a jury, we also dealt with a situation where it was rectified the following day. I didn't hear Mr. Shea talk about that, but that certainly also flies in the face of his argument that it's too late for us to do anything about it. Here we are 2 days later. There's nothing in Randall that says it has to be addressed at the time. In Randall, it was a day later. Here we are 2 days later out. The conviction was upheld in Randall. The Ninth Circuit Court of Appeals, last time I checked, this court is in the Ninth Circuit. I don't mean that to sound flip, Your Honor, but I believe it is controlling. And if the court follows the procedure that was approved of in Randall, I think that should be sufficient. I think because, and I don't want to leave the court with the impression that I am abandoning the defense position that the door has been opened to the statements to Mr. Jones as well. But if the court is not inclined to admit that evidence to the jury, although I think it should come in, we have the statements themselves recorded in a digital format, and they could be presented to the jury in a very concise and clear way without the need to reopen argument, without the need to call additional witnesses. I don't think it would be disruptive to the jury deliberation process. The only thing it would do is allow the jury to make a better informed decision and sift through the half-truths that were foisted upon them during closing argument. Thank you.
Judge, if I may.
No,
I was
no.
challenged to offer a case, Judge.
Mr. Shea, I'm done.
I was
Okay?
challenged to offer a
I
case.
understand that. I'm not taking any more argument. Please have a seat. I'm going to deny the motion for a mistrial. I don't find that Mr. Barker intentionally, with any kind of malice or calculation, deliberately or through some sleight of hand, tried to mislead the jury in this case. I do find, and the concern that I have, again, is the one that I stated. The context is what I'm concentrating on, and I believe that either defense or prosecution, but both parties were sent this excerpt, and I'm reading from looks like page 5 of part of Mr. Barker's closing argument, and I'm starting at line 23. And then he says, now for all of those reasons, or any of those reasons, self-defense does not apply. But if you needed any further proof that what the defendant did was not self-defense, what did he say it was? That night, how did he talk about it? Because the defendant himself does not really believe he was justified. And then he goes into what he talked about to Mr. Acevedo, what he talked about to Mr. Pletke, and then it goes to Deputy LaBarle's statement. And that is the statements that I am concentrating on, because those were the statements that he made while he was in police custody. And he indicated, he's admitting right there that he did something wrong. He's not discussing that he was justified. He's not saying that what he did was correct or right. The defendant realized in that moment that he was arrested for a reason, that what he did was wrong. Now, it wasn't until later, of course, when he had an audience with the police in a police station on the record that he started talking about, well, these people were trying to kill me. Right. This is in the context of Mr. Jones' self-defense claim. And I don't think it's necessary, or I don't think there's some sort of magic incantation that for anyone to assert a self-defense claim, you have to use the word kill. I don't think that's required. There were self-defense claims, statements made by Mr. Jones that could legitimately be argued as self-defense. And the issue I have now, I wholeheartedly agree with Mr. Shea, is we have the trial is a search for truth and justice. This trial is continuing. The jury is deliberating. They're trying to continue this search for truth and to render just verdicts in this case. My concern is that they have been left, because the credibility of Mr. Jones' self-defense claim was put forward to the jury and put forward in such a way that it appears that the first time he raises a self-defense claim is when he is sometime into that 8-hour interview with the police, that the jury does not know that even prior to that, within 20 minutes of being placed into the police car, he was making statements that could have been legitimately argued, but for this court's ruling that those statements were self-serving hearsay. So what I am proposing is a curative instruction. Carrie, I just printed out 2 copies. Would you bring it out to council, please? And I'll give the parties 10 minutes to figure out what edits they want to do. I am proposing that the jury be instructed this way. Members of the jury, the court has determined that a statement inadvertently made by Mr. Barker during the prosecution's initial closing argument was inaccurate. The statement is as follows. Now, it wasn't until later, of course, when he had an audience with the police in a police station on the record that he started talking about, well, these people were trying to kill me, end quote. You shall be informed that Mr. Jones made the following statements while seated in Officer Park's patrol car and prior to his interview at the Flagstaff Police Station. 1, why were they trying to hurt me? 2, I thought I was going to die. You are to consider these statements as evidence. As such, you are free to accept these statements in whole or in part and to give them as much weight as you feel they deserve. We'll stand at recess for 10 minutes. Let me know what you think.
All rise. Thank you for standing, folks. Please be seated.
All right, we're back on the record. What has council decided? Mr. Davidson.
Your Honor, I have 2 or 3 requested additions. First, with regard to the first paragraph of the court's proposed instruction, I would suggest that we include some language that could orient the jury with regard to what sequence of the events the prosecutor was referring to when he says, now it wasn't until later, of course. I believe that these statements by Mr. Barker immediately followed a discussion of Stephen's interaction with Deputy LaBarley just outside or right next to the patrol vehicle. So I think it's important in order for the jury to put that in context that they understand at what point in time the prosecutor was referring to. That would be my first request. My second request, Judge, would be that we include the entire paragraph that the court includes beginning with the words, now it wasn't until later. I'd ask that we include the remainder of the paragraph as it appears in the court transcript. The third request, Judge, is that with regard to the second paragraph in the proposed instruction, that we make it clear or add language that Mr. Jones made the statements while seated in Officer Park's patrol car at the driveway entrance to Mountain View, because otherwise they're not going to know if it was in the parking lot of the station or at the parking lot of the...
Well, the problem with that is the statement, I thought I was going to die, was made on the way to the police station and not in front of the Mountain View parking lot.
Your Honor, I agree in watching that video over and over again that there was some movement of the vehicle, but I think it's pretty clear if you listen to Officer Park's radio traffic after Stephen makes that statement, it's pretty clear he hadn't yet left. He makes a comment to his dispatcher that he's transporting, and he also calls out his 101 mileage, which, as I assume the court knows, means that they're asking the dispatcher to document the starting mileage and their ending mileage so there can be no suggestion afterwards that they went somewhere other than directly from point A to point B. So I think if we re-review that, it's pretty crystal clear that although Officer Park's vehicle had moved a little bit, he was still in the proximity of other emergency vehicles that were converged around the Mountain View parking lot.
I'll let you take a look at it, but I'm almost positive that it shows the deputy moving and there's another car following behind him. I think you can hear his blinkers, his turn signals, and you can see it turning, and you see other cars pulling in behind him. But we can take a look at it if you want to.
And admittedly, Judge, it's body cam footage. It's not entirely clear. We don't have a full shot of through the windshield of the roadway, so we can take a second look at that. And I may well be mistaken. Finally, Judge, the first statement Mr. Jones made that the court seeks to provide the jury with why were they trying to hurt me. There's a subsequent statement made by Mr. Jones why did you make me do that, that I think is frankly more central to the issue of self-defense, because in that statement, Mr. Jones is incorporating both the concepts of the fear that he faced and what he did in response to that. Certainly, why were they trying to hurt me? I thought I was going to die, are statements that support his self-defense claim. But if what we're trying to do is set the record straight about Stephen articulating a concern about his safety such that he had to act in self-defense, I think the language, why did you make me do that, is more reflective of that. I think that can be clearly heard to the point where there's no dispute about those being the words that left his mouth.
Let me also, I'm going to make, as just so you're aware, I'm going to make a ruling. I think this whole issue of the video is one that I think is going to have to be fleshed out by better minds than mine. But my concern about the impact of video is that I do not want this to become, nor do I think any trial should become, a battle of videos, especially where the emotional impact of those videos is so great that even to those of us who have done this work for many years feel the emotion of those statements and of what is portrayed in the video, such that now, rather than the jury making decisions based on facts and testimony and evidence and issues of credibility, it becomes a battle of which video portrays the most emotional power on that. And so I know that I have let in, I think, 2 clips on that. I still stand by my rulings to allow those 2 clips, and my ruling to disallow the playing of, I think, a 13-minute portion of what happened that the prosecution sought to introduce. But I'm not going to allow the jury to hear those statements from the CD or DVD. So I feel that we should inform the jury as to statements made, but I'm not going to allow the playing of those statements for the jury. Mr. Barker, Mr. Shea, what's your proposal?
Thank you, Judge. I'd like to go through the statement that the state suggested the court actually give, and then as counsel gave argument, I'll give argument afterwards as to why I think that's appropriate. But the court's instruction seems to attempt to give this to the jury in a balanced way. The state would recommend something very similar. First, the state actually recommends taking out the first paragraph altogether, and giving some kind of different indication. But if the court is inclined to give some version of the first paragraph, the state would recommend something to the effect of, members of the jury, the court has determined that a statement inadvertently made by Mr. Barker and to which the defense did not object and was only inaccurate as to the location of the statement made. The statement is as follows. Now, it wasn't until later, of course, when he had an audience with the police in a police station on the record, that he started talking about, well, these were people trying to kill me. You shall be informed that Mr. Jones made the following statements while seated in Officer Park's patrol car and prior to his interview at the Flagstaff police station. Why were they trying to hurt me? I thought I was going to die. You should attach no special weight to this evidence. Rather, you are to consider these statements in light of all of the other evidence. As such, you are free to accept or reject these statements in whole or in part, to give them as much weight as you feel they deserve. And then the state would recommend that the court refer back to the instruction that lawyers' statements are not evidence. So if I may, the reasons I make these recommendations, Judge, is lawyer statements are not evidence, is the instruction that all of the case law refers to when evaluating when things are argued, whether or not they were accurate during the closing argument. So referring back to the jury, that's really the curative instruction that the court often uses in situations had there been a timely objection, that would have been included. So the state argues that it should be included here. I think it's important to point out to the jury that this evidence has exactly the same weight as all the other evidence. It needs to be considered in the totality of the circumstances, and that they are free to reject it if they so choose, as they are with any piece of evidence. With regards to the first paragraph, the reason that the state, okay, so there's two arguments here. The first one is, based on what I'm reading here, what the court provided, okay? Now, it wasn't until later, of course.
Mind you, this was done at about 4 a.m. in the morning.
I get it.
Okay.
Now, it wasn't until later, of course, when he had an audience with the police. Both of those things are still accurate in Officer Park's police cruiser. So when he had an audience with the police, and at the station is the only thing that's different, because he was on the record when he started to talk about these things. The only thing that's different is that he's sitting in a police cruiser instead of sitting at the police station. So I would argue that if the jury is going to be pointed out an inaccurate statement by the state, that the inaccuracy itself be indicated, and the only inaccuracy is the location where the statement was made. I would argue it's not even an inaccuracy, but at best, it's only the location. He's in police custody. When he had an audience with the police on the record that he started talking about these things. The location is the only inaccuracy. And then as far as the defense not objecting, and this is my final argument, Judge. There were patent inaccuracies, patently improper arguments offered by the defense. The egregious example that Mr. Barker actually pointed out in his close was inviting the jury to speculate as to what the other injuries on Mr. Brew's hands, in fact suggesting that those were as a result of fighting. Mr. Brew is a lacrosse player, okay? Those injuries are from lacrosse or something else, and not from fighting. Defense counsel knows that. It was an intentionally wrongful, improper argument that was given. Mr. Barker dealt with it the way that you're supposed to deal with it. He could have either objected, he elected not to. He dealt with it during his argument. But to point out to the jury one inaccuracy on the part of the state, and to not put any balance in as to the defense failure to object, would be to then suggest that everything else that was argued was accurate. That's just one example. I could come up with several more improper, inaccurate arguments on the part of the defense. So really, if we wanted to comb through the arguments and find inaccuracies, we'd find a heck of a lot more in the defense argument. That's the reason the state's offering the balance that the defendant didn't object to. That's the reason. And I think what we're talking about here is we're trying to rebalance. The court has identified something that it believes has placed the circumstances out of balance. We're trying to put it back into balance, and I would argue to you, Judge, that without stating that the defense didn't object to it, we have a hard time putting it back into balance, because then we'd have to go through all of the arguments and point out all of the inaccuracies.
Okay.
Thank you.
Thank you. 2 minutes.
Very briefly, Judge, I think that the state's hair splitting continues as they try to assert to the court that the only inaccuracy in the prosecutor's statement has to do with whether there was a police audience or not. I think when you view the statement in its totality, at least that full second paragraph that I would ask the court to include, it's pretty obvious what was being implied. And I don't know that Officer Park was even in the car when Stephen made both of these statements. So I think the argument that he was in a police audience may not be supported by the evidence. Moreover, there's no evidence to suggest that Stephen even knew he was being recorded in the back of Officer Park's car, contrast that with what the prosecutor said about Stephen being, quote, on the record back at the police station. So I think we should just give the whole paragraph. I think that the court has provided the state enough cover by characterizing the prosecutor's remarks as being inadvertently incorrect. The defense did object. The state has some argument with regard to the timing of that, but it's not a correct statement to say that we didn't object. And frankly, when or if the defense objected has no bearing or relevance as to this particular evidence and how it fits in with all the other evidence they are to consider. I think the language that the court has in this final paragraph, asking them to, or advising them that they are free to accept or reject it and give it as much weight as they feel it deserves, provides the proper context to it. I don't think we need to be as long-winded as the state recommended, and I certainly don't think that we need to add another instruction about the lawyer's comments not being evidence. They already have that. If we repeat that, it's going to give that undue prominence over the other instructions to the point where they may not consider the other instructions to be equally as important. So I suggest we give it as is, with, of course, the recommendations that we made.
Do you want to take a look at that video to make sure?
With regard to the location?
With regard to the location.
If I may.
Please want to come on up, Mr. Shea, Mr. Parker.
Okay, it looks like there was some movement on the part of Deputy Barrow, but I don't necessarily disagree that he was still at the scene. But you know, where I have that is simply at the issue is he made those statements while seated in Officer Park's car and prior to his interview at the Flagstaff Police Station. So I don't know that we necessarily need to say that he was still at the scene. And you're offering the language while still at the scene?
Correct, Your Honor. Or
You're still in front of Mountain View?
still in by the Mountain View parking lot.
Judge, if we're going to do that, then we should tell the jury what time, how long he was sitting there, because it was an hour later that he makes a statement, I thought I was going to die. Time matters. So either we keep it the same or we add that language in if you're going to give counsel's language.
Here's what I'm going to read to the jury. Members of the jury, the court has determined that a statement inadvertently made by Mr. Barker during the prosecution's initial closing argument was inaccurate. The statement is as follows. Now, it wasn't until later, of course, when he had an audience with the police in a police station on the record that he started talking about, well, these people were trying to kill me. He shall be informed that Mr. Jones made the following statements while seated in Officer Park's patrol car and prior to his interview at the Flagstaff Police Station. 1, why were they trying to hurt me? 2, I thought I was going to die. You are reminded that the lawyer's statements are not evidence. You are to consider these statements in light of all the other evidence. As such, you are free to accept these statements in whole or in part and to give them as much weight as you feel they deserve.
Judge, the only addition, you are free to accept or reject, which mirrors the language in the jury instructions, not just that you are free to accept.
Free to accept or reject. I apologize. Let's call the jury. Carrie, would you, or Eli, would you check, make sure we have the jurors, and bring them back in, please? You don't have to stand. I'm just standing because I've just been sitting. If you want to remain seated, that's fine. All right, I'll ask the members of the jury to be seated. Members of the courtroom can now be seated. We're on the record. Mr. Jones, defense counsel, state are present. All members of our jury are present. Folks, I'm going to read you a statement. Members of the jury, the court has determined that a statement inadvertently made by Mr. Barker during the prosecution's initial closing argument was inaccurate. That statement is as follows. Now, it wasn't until later, of course, when he had an audience with the police in a police station on the record that he started talking about, well, these people were trying to kill me. You shall be informed that Mr. Jones made the following statements while seated in Officer Park's patrol car and prior to his interview at the Flagstaff police station. 1, why were they trying to hurt me? 2, I thought I was going to die. You are reminded that the lawyer's statements are not evidence. You are to consider these statements in light of all the other evidence. As such, you are free to accept or reject these statements in whole or in part, and to give them as much weight as you feel they deserve. I'll go ahead and stand at recess pending your deliberations. Okay, we'll stand at recess.